The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oh, yea, oh, yea, oh, yea. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
Justice Kennedy has our opinion this morning in Case 14-556, Obergefell versus Hodges, and the consolidated cases.
These cases come to us from Michigan, Kentucky, Ohio, and Tennessee. Those states define marriage as a union between one man and one woman. Petitioners are 14 same-sex couples and 2 men whose same-sex partners are deceased. Respondents are state officials. Petitioners claim that in these states, respondents violate the 14th Amendment, in some cases by denying them the right to marriage, and in some cases by refusing to recognize their marriages which were licensed in other states. Petitioners filed these suits in United States district courts in their home states. Each district court ruled in their favor. Respondents appealed to the Court of Appeals for the Sixth Circuit. It consolidated the cases and reversed. This court granted review limited to 2 questions. First, whether the 14th Amendment requires states to license same-sex marriages, and second, whether that amendment requires states to recognize same-sex marriages that were licensed in states which do grant that right. Since the dawn of history, marriage has transformed strangers into relatives. This binds families and societies together. And it must be acknowledged that the opposite sex character of marriage, one man, one woman, has long been viewed as essential to its very nature and purpose. And the Court's analysis in the opinion today begins with these millennia of human experience. But it does not end there. For the history of marriage is one of both continuity and change. As new dimensions of freedom have become apparent to new generations, the institution of marriage has been strengthened by evolution over time. Until recent decades, few persons had even thought about or considered the concept of same-sex marriage. In part, that is because homosexuality was condemned and criminalized by many states through the mid-20th century. It was deemed an illness by most experts. Of necessity, a truthful declaration by same-sex couples of what was in their hearts had to remain unspoken. Over the past half century, however, substantial cultural and political developments, following those, same-sex couples began to lead more open lives and to establish families. This led to an extensive societal discussion and a shift toward greater tolerance of same-sex relationships. Against that background, the legal question of same-sex marriage arose. The courts have written a body of law considering all sides of the issue. And after years of litigation, legislation, referenda, and public debates, the states are now divided on the question of same-sex marriage. The Due Process Clause of the 14th Amendment long has been interpreted to protect certain fundamental rights central to individual dignity and autonomy. The identification of these rights is guided by history and tradition, but the past alone does not rule the present. For the nature of injustices, we do not always see it in our own times. This Court has held the right to marry as fundamental. Of course, in doing so, it presumed an opposite-sex union, one man, one woman. But the Court has expressed constitutional principles of broader reach, and in assessing whether the force and rationale of its cases apply to same-sex couples, the Court must respect the basic reasons why the right to marry has been protected. A first premise of the Court's cases is that the right to personal choice regarding marriage is inherent in the concept of individual autonomy. Like other choices protected by the Due Process Clause, decisions concerning marriage are among the most intimate that an individual can make. Indeed, as the Supreme Judicial Court of Massachusetts has explained, the decision whether and whom to marry is among life's momentous acts of self-definition. This is true for all persons, whatever their sexual orientation. The second relevant principle is that marriage supports a two-person union, unlike any other in its importance. Marriage dignifies couples that wish to define themselves by their commitment to each other. In Lawrence versus Texas, the Court held that private intimacy of same-sex couples cannot be declared a crime, yet it does not follow that freedom stops there. outlaw to outcast may be a step forward, but it does not achieve the full promise of liberty. Third, the right to marry safeguards children. Many same-sex couples provide loving and nurturing homes to their children, whether biological or adopted. Hundreds of thousands of children are presently being raised by same-sex couples. Excluding same-sex couples from marriage thus conflicts with the central premise of the right to marry, inflicting stigma, uncertainty, and humiliation on the children of same-sex couples through no fault of their own. Finally, marriage is a keystone of our social order. Thus, just as a couple vows to support each other, so does society pledge to support the couple, offering symbolic recognition and material benefits, including tax benefits, hospital visitation rights, child custody and support rules, and adoption rights. There's no difference between the same and opposite sex couples with respect to this principle. Yet by virtue of the challenge law, same-sex couples are denied the constellation of benefits states have linked to marriage. Many who deem same-sex marriage to be wrong hold that view based on decent and honorable premises. Neither they nor their beliefs are disparaged here. But when sincere personal opposition becomes enacted law, the requirements of the Constitution must be respected. Although the limitation of marriage to opposite-sex couples may long have seemed natural and just, its inconsistency with the right to marry is now manifest. It would diminish the personhood of same-sex couples to deny them this liberty. The right of same-sex couples to marry is derived, too, from the Equal Protection Clause. The Court's cases touching upon the right to marry, as well as its cases addressing the legal treatment of gays and lesbians, have long emphasized the relation between liberty and equality. The Court now holds that same-sex couples may exercise the fundamental right to marry in all states. No longer may this liberty be denied to them. The challenge laws excluding same-sex couples from marriage cannot stand under the Constitution. These cases also present the question whether the Constitution requires states to recognize same-sex marriage that were licensed in other states. In light of the Court's holding that same-sex couples may exercise the right to marry, it follows that the Court must hold, and now does hold, that the challenge bans on recognition are invalid. There may be an inclination, there is an inclination, in these cases to proceed with caution. It is most often through democracy that liberty is preserved and protected in our lives. Yet there's been substantial public deliberation over the past decades, and it is a central premise of our Constitution that fundamental rights depend on the outcome of no elections. The dynamic of our constitutional system is that individuals need not await legislative action before asserting a fundamental right. Of course, those who oppose same-sex marriage, whether on religious or secular grounds, may continue to advocate that belief with the utmost conviction. In turn, those who believe allowing same-sex marriage is proper may engage those who disagree with their view in an open and searching debate. This case concerns only what states may do under the Constitution. No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. In forming a marital union, two people become something greater than they once were, and would misunderstand petitioners to say that they disrespect or diminish the idea of marriage in these cases. They're pleased that they do respect it. They respect it so deeply they seek to find its fulfillment for themselves. They ask for equal dignity in the eyes of the law, and the Constitution grants them that right. For these reasons, and others set out in the opinion, the judgment of the United States Court of Appeals for the Sixth Circuit is reversed. The Chief Justice has filed a dissenting opinion in which Justice Scalia and Thomas join. Justice Scalia has filed a dissenting opinion in which Justice Thomas joins. Justice Thomas has filed a dissenting opinion in which Justice Scalia joins, and Justice Alito has filed a dissenting opinion in which Justices Scalia and Thomas join.
From the dawn of human history until a few years ago, for every people known to have populated this planet, marriage was defined as the union of a man and a woman. That is true for the Kalahari Bushmen and the Han Chinese, for the Carthaginians and the Aztecs, for any civilization at any time, at any place in the world, and certainly for those who wrote and ratified our Constitution. But today, 5 lawyers have ordered every state to change its definition of marriage to one that matches a new one that they favor. because those lawyers have, in their words, new insight and a better informed understanding of liberty. Just who do we think we are? I have no choice but to dissent. These cases are not about whether we think same-sex marriage is a good idea. The petitioners make strong arguments rooted in social policy and considerations of fairness. They have moving personal stories. Stories like theirs have played a major role in persuading voters and legislators in 11 states and the District of Columbia to revise their laws and adopt same-sex marriage. But this is a court, not a legislature. Under the Constitution, we have power to say what the law is, not what it should be. And while the policy arguments for extending marriage to same-sex couples may be compelling, the legal arguments for requiring such an extension are not. Our Constitution does not enact any one theory of marriage. The people of a state are free to expand marriage to include same-sex couples or to retain the historic definition. The majority bases its contrary decision on the Due Process Clause of the 14th Amendment. But allowing unelected judges to strike down democratically enacted laws based on rights that are not actually written in the Constitution raises obvious concerns about the judicial role. That is why our precedents have insisted that judges weighing claims of such implied fundamental rights must exercise caution and restraint, and they must ground such a right firmly in our history and tradition. The Court, of course, cannot do that with respect to same-sex marriage. No one would call the Court's approach today cautious and restrained, least of all the majority. It expressly rejects what it calls any, quote, inclination to proceed with caution, end quote. It acknowledges that on one side of today's question is the uniform practice of every civilization in human history. But on the other side, as the Court explains, there have been referenda, legislative debates, and grassroots campaigns, as well as countless, this is a quote, studies, papers, books, and other popular and scholarly writings. There has been, quote, extensive litigation in state and federal courts. Quote, this has led to an enhanced understanding of the issue, an understanding reflected in the arguments now presented for resolution by this Court. In other words, the Court is now ready to render its verdict on history and the institution that has formed the basic building block of human society since time immemorial. The majority relies heavily on cases recognizing a fundamental right to marry. These cases, of course, do not hold that anyone who wants to get married must be allowed to do so. Instead, they prevent a state from restricting access to marriage as the institution of marriage has been understood throughout history. Loving versus Virginia, for example, struck down racial restrictions on marriage between a man and a woman. But Loving did not create any right to make a state change its definition of marriage. It struck down racial restrictions on who could participate in marriage as historically defined. Removing racial barriers to marriage did not change what marriage was, any more than integrating schools changed what a school was. The majority also cites precedents implying a fundamental right of privacy. But the marriage laws at issue here do not restrict privacy in any way. Same-sex couples remain free to live together, to engage in intimate conduct, and to raise their families as they see fit. At the same time, the laws in no way interfere with the right to be left alone. Simply put, the privacy cases do not help petitioners because they do not seek privacy. They seek the opposite of privacy, public recognition. Ultimately, only one precedent supports the majority's interpretation of the Due Process Clause, Lochner versus New York. In that case, decided in 1905, the Court struck down a state law setting maximum hours for bakery employees. The Court did so based on its own conception of liberty, in particular its view that the Constitution protects, quote, a general right of an individual to be free in his own person. In the years after Lochner, the Court struck down nearly 200 other similar laws that the Court saw as a, quote, interference with the rights of the individual, Now, the Lochner era is now regarded as one of the most unprincipled periods in the Court's history. The problem with the Court's approach was not that the particular liberties the Court enshrined were undesirable, but that such an unrestrained enterprise had no basis in the Constitution. As Justice Oliver Wendell Holmes explained in his Lochner dissent, the Constitution is not intended to embody a particular economic theory. It is instead made for people of fundamentally differing views. Just so here. The Constitution is not intended to embody a particular theory of marriage because it is made for people of fundamentally different views. As Justice Holmes wrote in another case, the criterion of constitutionality is not whether we believe the law to be for the public good, and so too here. The Court eventually agreed with Justice Holmes and repudiated Lochner. But today we see it resurrected as the majority relies on its freewheeling conception of individual autonomy to justify striking down the marriage laws of more than half the states and transforming an institution that has endured for millennia. In the majority's view, traditional marriage laws impermissibly restrict petitioners' right to, quote, define and express their identity and to exercise the right to personal choice regarding marriage that is inherent in the concept of individual autonomy. The majority's conception of liberty echoes nothing as much as Lochner's invocation of, quote, the right of the individual to his personal liberty or to enter into those contracts which may seem to him appropriate or necessary. Like the Court in Lochner, which concluded that we do not believe in the soundness of the views which uphold this law, the majority today relies on its own understanding of what freedom is and must become. And like the Court in Lochner, which believed that the interest of the public is not in the slightest degree affected by the bakery hours at issue, the majority today insists that same-sex marriage would pose no risk of harm to themselves, to the same-sex couples, or third parties. Now, the elevation of the fullest individual self-realization over the constraints that society has expressed in law may or may not be attractive moral philosophy. But a justice's commission does not confer any special moral, philosophical, or social insight sufficient to justify imposing those perceptions on fellow citizens under the pretense of due process. There is indeed a process due the people on issues of this sort, the democratic process. Respecting that understanding requires the Court to be guided by law, not any particular school of social thought. Now, ultimately, the deepest problem with the majority's decision today is the disrespect it shows the democratic process. In recent years, people around our country have engaged in a serious and thoughtful debate about same-sex marriage. Voters have cast ballots in favor or opposed and sometimes changed their minds. Political leaders have similarly re-examined their positions and reversed course or explained adherence to old convictions confirmed anew. When decisions like this are reached through democratic means, some people will inevitably be disappointed with the results. But those whose views do not prevail at least know that they have had their say and accordingly are reconciled to the result of a fair and honest debate. They also know that they can try again as their ideas gain acceptance and momentum elsewhere. That is what happened in Maine, where voters adopted same-sex marriage just 3 years after upholding the traditional definition of marriage. Today's decision puts a stop to all that. There will be consequences to shutting down the political process on an issue of such profound public significance. Closing debate tends to close minds. Indeed, however heartened the proponents of same-sex marriage might be on this day, it is worth acknowledging what they have lost, and lost forever, the opportunity to win the true acceptance that comes from persuading their fellow citizens of the justice of their cause. And they lose this just when the winds of change were freshening at their backs. Now, in the face of all this, a much different view of the Court's role is possible. That view is more modest and restrained. It is more skeptical that the legal abilities of judges also reflect insight into moral and philosophical issues. It is more sensitive to the fact that judges are unelected and unaccountable and that the legitimacy of their power depends on confining it to the exercise of legal judgment. It is more attuned to the lessons of history and what it has meant for the country and the court when justices have exceeded their proper bounds. And it is less pretentious than to suppose that while people around the world have viewed an institution in a particular way for thousands of years, it is 5 lawyers on the present court who are the ones that have been chosen to burst the bonds of that history and way of life and to command that every state follow their lead. Now, if you are among the many Americans of whatever sexual orientation who favor expanding same-sex marriage, by all means celebrate today's decision. Celebrate the achievement of a desired goal. Celebrate the opportunity for a new expression of commitment to a partner. Celebrate the availability of new benefits. But do not celebrate the Constitution. It had nothing to do with it. I respectfully dissent.
God save the United States and this honorable court.